I'm going to talk for about 30 minutes and then we can have a Q&A session. I'm really excited to hear what you think. I guess before I get started, it would be remiss of me not to reflect a little bit on the moment that we're in, which is one in which there's been, both in the UK where I'm based normally, although I'm sitting in Boston right now, and the US, and I'm wondering how it is in Canada, so maybe someone could mention this also in the Q&A. There's been a kind of a targeting, an intellectual targeting of anti-racism in a way that's taken the form of arguing that critical race theory, which is this very specific intellectual tradition, and it's interesting that that's garnered so much attention in this type of targeting, but it's an intellectual targeting about anti-racism that takes a form of argument that anti-racism is divisive. So anti-racist work and naming racism and actually coming to terms with patterns of racism, including structural racism, is a divisive concept. So that's the type of discourse that we're confronted with in this moment. And I just wanted to make the connection between that as our contemporary moment and the things that I'll be talking about today, because we realize that this is not a new argument. It's not a new criticism of examining difference. And as you'll see with the European examples, and particularly the German example, it's the concept of racism, I think, has become one, or it's discussed in certain political circles as one that is divisive just by being its historical self, its construct. So racism itself as a construct is divisive, but that ignores the actual violence that people suffer as a result of racism. So if we can't name race and racism, we can't actually identify exclusion, marginalization, and oppression, and we can't theorize it historically, which is quite anti-intellectual, which is another kind of frame of this critique of anti-racism, that it's anti-intellectual. So these are things that we've been confronting quite a lot, I think, in anti-racism work, and it's not new. And so I think that's worth saying. So I'll be referring to this the piece that I wrote called Black Lives and German Exceptionalism off and on in the next few minutes. And it's just to give a grounding to some of the work that I've been doing around race in Europe more broadly. And so I'll just read the first paragraph of it as an introduction to some of what I'm going to say about the law and race. The killings of George Floyd, Breonna Taylor, and Elijah McClain by police officers in the United States has served as a crystallizing moment around which a new dimension of longstanding movements have come into being. Floyd, Taylor, and McClain were, like many others before them, unlawfully killed by uniformed law enforcement officers in the circumstances where civilians would have had little protection from the swift charges of murder. The officer who killed Floyd was charged with second-degree murder, arguably only after public protests sparked by the video of the officer kneeling on his neck for nearly 9 minutes while he pled for his life. The officers who killed Breonna Taylor have not yet been charged, or they hadn't been charged at the time of my writing this. The officers whose actions led to McClain's death had been cleared of all wrongdoing. The current protests in the United States and around the world are not only about policing, they can't be understood without also understanding systems of racial oppression, including lynching, political repression, development of mass incarceration, and the disproportionate impacts of the criminal justice system on the Black working class. But of course, the protests are international. The nature of policing, not only in the United States, but in many places around the world, and certainly in Europe, is such that holding police to account for deaths of innocent people is not only statistically improbable, but it's designed to be legally impractical. Such deaths are argued to be justified in the course of policing as collateral damage, necessary for the general effectiveness of policing practices. To make matters worse, racialization, gender, migration status, and mental health vulnerabilities play a role in the ways police encounter civilians, as well as the narratives that result in these encounters, in the media, in the courtroom, and in most any institutional apprehension of the encounter discussed or debated thereafter. So demonizing the victim and that sort of thing. This is easy to deduce, given the ever-presence of societal racism, xenophobia, and a lack of care for those who are mentally vulnerable in our societies, not to mention their various intersections, which magnify and transform their impacts. However, these things are difficult to quantify, given the lack of data, language, and legal recognition of patterns of institutional and structural forms of bias. I'll attempt to provide a sketch on how the law underwrites the invisibility of racism in Europe. So just for a moment to also reflect on the social discourse that race and racism and discussion of difference in terms of race is not a European thing. So in academia, as well as in discussions with legal practitioners, I've been confronted with the idea that a more appropriate way of looking at difference is ethnicity, which is more tightly scripted around social and cultural practices, which orients us around discussions of multiculturalism and integration, rather than about racialization, which can take other types of forms, which don't necessarily relate to people's cultural expressions or religious backgrounds. For example, someone who's grown up in Germany and doesn't look German because they're people of color may experience racism in a way that's not refracted through those lenses of culture in the same ways. Of course, things are imputed onto those people just in quite a similar way, but racism does a type of work to help us understand that type of exclusion and marginalization that other terms like ethnicity or xenophobia don't do. So just to get a sense of what's happening legally in terms of race in Europe, I think that from my perspective is important because I'm looking at the intersection of law and society. So what does the law say about race and how does it intervene into race and racism in society? I'll preface this by saying the law doesn't really have, it's not equipped in terms of it's not written and it's not understood to provide lots of remedies for structural types of discrimination, let alone structural racism. So that's, I think, the conjuncture that we're in is figuring out how the law could be of service in identifying and combating structural forms of discrimination or exclusion. So in terms of the European-wide jurisdictions, so the European Union is made up of 27 member states. It has primary treaties that govern its workings, and that includes provisions about equality and equal treatment and fundamental rights. The more specific treaties are the secondary legislation, of the European Union, gives member states, including Germany and until recently the United Kingdom and France and Spain and Italy, and the member states, it gives them a direction that they need to push their legislation towards. So the directives, including the race directive that was passed in 2000, gives obligations, sets out obligations for states to combat discrimination and to protect against discrimination in the workplace and in other sectors in a very specific range of ways. And those directives, well, that directive has made it such that member states need to then adjust their national legislation to comply with those directives. And they've done this in a range of ways because the European Union is set up so that directives have to be then implemented by member states, and that can take a range of ways. So the way that, I'll talk about how they've done it in a moment. There's also the European Convention of Human Rights, which is governed by the Council of Europe, which is a larger set of member states. I believe there are 47, and that protects against human rights violations. which is a slightly different register of protection. It's not necessarily about the everyday workplace discrimination type of thing. It's about where a fundamental human right has been violated by a member state, or it hasn't been prevented from being violated by that member state. And sometimes that violation is a result of some discriminatory practice. So if your right to life has been violated, you've been killed wrongfully somehow, and it's for a racially discriminatory reason, then you can say your Article 2 right to life has been violated, and there's a racial reason, and that's Article 14. So you can bring it into, you can bring race and racism into play that way. On the EU level, because that's where we're talking about policies that are much more specific and integrated into member states' national laws, there's a new action plan to combat racism. And the action plan calls for things like fair policing and protection. And I'll say this, a lot of this, I think, is tied in with the momentum of the Black Lives Matter movement, which has become international and which has gotten the attention of lots of policymakers, even across Europe, because of the European dimensions of the discussions about race and racism. So fair policing and protection, which includes training, which many of us might be skeptical about, what types of training and how training actually can be, how effective it can be, and gathering data on police attitudes towards minorities. So it's a bit light touch in terms of policing. But there's one area of this action plan that has the potential to be quite thoroughgoing in its effect in Europe. And I think that's better data collection in general. So it calls for a consistent approach to EU member states on a quality data collection for more and better data disaggregated by racial and ethnic origin. So the disaggregating of data means that you're not just collecting data on what happens to people or the general housing market, where you keep statistics on how many people are applying for certain housing, or that's just an example, but rather you keep statistics that are actually broken down by categories of racial or ethnic origin. In the UK, for example, monitoring forms are usually attached to job applications, and they're optional forms and they're disconnected to the application. So they should theoretically go into a pile of anonymous forms where then an employer can always see disaggregated by racial and ethnic origin, but also by gender, by sometimes religion. It depends on what you ask on the form. Can see what the applicant pool is, so can then spot potential exclusions. If a certain type of applicant is getting excluded on a constant basis, that's a way to track it. The problem with data collection at the European level is that different member states interpret their obligations to combat racism in different ways. And some member states, going back to my initial comment about looking at anti-racism as divisive, some member states interpret their obligation to combat racism as an obligation to eliminate the category of race. And by eliminating the category of race, you eliminate the problem of race and racism, because people are then not allowed to use race as the category, which means they can't be racist. So even saying that, I kind of have to giggle, because you can't wish something away by eliminating the language for it. And actually, if this action plan says anything, it says that there's a recognition that the data is actually necessary in order to hone our compliance to combat racism. So in the national legal orders, race is seen as, or the obligations around anti-racism are seen quite differently. So I mentioned in the UK, these monitoring forms are kept. It's partly because race is a part of the language of equality law. It's used, of course, with the understanding that race as a scientific concept is false, in inaccuracy, and it's a racial concept that's, you know, bound to, you know, rooted in biology, but bound to have social implications. That the social construct of race is the category that we're dealing with. We're dealing with how it's used and deployed as a concept in society and how it excludes. So the concept is used quite thoroughly in the legal context, at least in terms of discrimination law. So the Equality Act of 2010 basically brought in all of these different equality grounds, but race had been identified as a grounds for protection, specific protection, as early as the 60s in the UK. In Germany, there's the Basic Law, the Grundgesetz, and the Basic Law is the German Constitution, and that has a provision that covers racial discrimination in it. That constitutional provision has historically been difficult to then bring into a courtroom and litigate in the employment context or in public services, because only in 2006 did Germany adopt the German law of equal treatment, which is basically its equality provision. So that makes it more specific that you can bring a claim based on racial discrimination in contexts like employment, and it defines direct discrimination and indirect discrimination, and those things are linked to the 2000 EU directive. So one can argue credibly that were it not for the directive, Germany might not have adopted or might have been slower in adopting an equal treatment law. And then there's a National Anti-Discrimination Office, which hears claims and basically keeps stock of who's making claims for what grounds of discrimination. France, and I'm not going to go through all of these in detail because the UK, Germany, and France, I think, give a good range of what's happening in Europe, and then I'll focus more on Germany. France is probably the most extreme in terms of outlawing the category of race. It's probably the only country to outlaw it criminally. So until recently, race was covered under the French constitutional provisions as a grounds that on which you couldn't treat someone differently. But it was removed because the law in France is that race is not a category that is allowed, and therefore to have it in constitutional provisions is a bit of a contradiction. So this is the argument. And so it was removed from the constitutional protections, but it remains as a criminal category under a 1970s law that prevents people from using it. So what that means in an employment context, for example, is that if an employer is discriminating, potentially being discriminatory, and there's an argument that it's racially discriminatory, because it won't be direct, it won't be explicit, because it's criminally outlawed to be explicit. It'll be, you know, some other form of exclusion that doesn't rely on the explicit use of racial categorization. Then the remedy is for a case to be brought by or investigation to be launched, and potentially a case to be brought by the Ministry of Labor, which involves the person who's experiencing things to go to Ministry of Labor, the Ministry of Labor to file a kind of a criminal action against an employer. And that is a cumbersome process, but also a politically charged one that the Ministry of Labor is unlikely to involve itself in. And so in broader terms, it's really up to non-governmental organizations to try to make a case that there are patterns of treatment that resemble some sort of racism, and to bring that to the attention of the public. And that's also a difficult and risky endeavor. So in France, this has meant that it's difficult to actually identify when racism is happening, even just when we're talking about discrimination. And just very quickly, I mentioned that race is a commonly used concept in the UK, and statistics are kept on race. They're disaggregated by race, and discriminatory policies practices are tracked. This includes in the policing context and in the employment context. And whereas in Germany, the word race is also contested. So the German word for race is Rasse, and that word is highly charged, and it's not a, it doesn't have the same history as in the English-speaking world, because in German, many people feel that it's connected so much to Nazism and biological racism as per that particular regime. And that means that discussing race in German in the contemporary setting tends to orient the discussion towards this dilemma of, is race the right concept? And sometimes that goes in the direction of, well, while this may be the popular feeling towards the concept, it is the translation of the term that actually does the work that we need it to do. So we need to keep that term in play, especially because in a regional or global environment, it's hard for Germany and German scholars and German lawyers to have a conversation about European protections against racism without having a German word for race. So that's one direction. And another direction is race in the German lexicon does not work per se. And so we have to either replace it with more descriptive terms or use the English word or find a proxy that we can live with. So this is kind of a split that is happening. And layer on top of that, that some people feel uncomfortable with the government having a lot of control over using concepts like race to describe people and keeping statistics on people. So this is kind of a challenge in the German context. And I've already mentioned the French context where race is outlawed. And so in general popular use, it's just not possible to use race openly. Just to give some insight in the last few minutes, I'm not going to talk about the UK too much. Because this is really about Germany. So if you have questions about the UK, we can integrate them in the Q&A. But the broader political field in Germany is also extremely blunt. I don't know if I want to say that this is only a cultural thing. It's also about the way that difference is considered in Germany and what counts as racist or racialized speech. I mean, it's certainly racialized, and I think there are debates in Germany about what to call racist and then how to deal with it. So one of the most powerful political parties in Germany, I think it's still the third or fourth most biggest political party, is the Alternative for Germans, Alternative for Germany, the AfD party. And they had a campaign a few years ago that was it was based around an anti-immigration platform, but it was lodged towards, its base, and it took the language of biological racism. I mean, some of it did at least. So this first poster definitely does. And so New Germans in Germany, Neue Deutsche, refers to people who are maybe first or second generation Germans who have what in Germany is phrased as immigration background or migration background. And a lot of these people are Turkish German or from different areas around Germany, so Eastern Europe, etc. But also any people who are not white, right, are sometimes classed in this category. And this poster says, "New Germans, we'll make them ourselves." And it has a pregnant white woman on it. And this was, I'm walking around neighborhoods where I lived for many years and seeing these posters around. It's quite shocking. And it also underscores this, this return to the biological forms of racism that we see emerge when racism and kind of a nationalism that takes the form of anti-immigration politics come together. And these types of discussions bring the conversation even more towards, I don't want to say right or left, it's away from thinking through the importance of having these concepts exist in our lexicon and in our legal system that help to identify these forms of exclusions and practices and provide a remedy to them. So this isn't my way of arguing for a restriction on free speech, but it is a way of arguing for having an easy route to being able to identify and discuss racism. And so to return to the conversation about the executive order in the US or the proclamations do not use the term structural racism or concepts like critical race theory or diversity trainings, how they are situated in the contemporary political time that we're in, where nationalism is kind of at the center. And then the second poster, diversity, already got that, and it shows different white women, ostensibly white German women in different traditional German dress from different parts of Germany. And for the last 2 or 3 minutes, because I know I'm running to the end of my 30 minutes, I just want to mention a formative case that has been the center of a lot of my research. And while it's maybe at a tangent to some of the main political debates around racism and structural racism, it's only at a tangent there because it's difficult to see the patterns of police brutality in racism, in Germany. And police brutality is obviously, it exists, virtually everywhere. But the patterns and the scope and the actual relationship between what happens, what physical violence might happen to a person and how that's dealt with in the courts afterwards is the issue that in Germany is very difficult to uncover. And that is partly because of the legal structures. It's partly because of our inability to track the disproportionate impact that certain communities face when encountering police violence. And it's partly because all of this is frustrated by the inability of families and members of the public to get involved in these types of cases. So limited transparency and a lack of support foundationally for families to get involved when their loved ones die in custody. And I'm happy to take questions about this in the Q&A, but very briefly, Oury Jalloh was a man who was from Sierra Leone and was in Germany applying for asylum. His application had been rejected, and he was awaiting the second hearing. So he was still in the country on valid paperwork, which is beside the point. I just mentioned that because of the vulnerability that he was in. He was in a vulnerable position vis-a-vis the police because of his status. He was arrested one night in 2005 because he was reported to have been bothering people who were sweeping up the street in the city of Dessau very late at night, and he had been drinking. He was at a club, but he wasn't being aggressive. And at some point, he just sat along the roadside, and the police arrived because they were called. And the police put him in handcuffs. They brought him to the station. And there's where the story kind of disappears into the whirlwind of testimony by the police. Because later that morning, he was tied, or he was chained by 4-point restraints by his wrists and ankles to a bed, and he burned to death. So the police argue that he burned himself to death because they said he must have hidden a lighter in or around his body and figured out a way to open the mattress even while being chained to it and burn the mattress so quickly that they couldn't reach him in time. They also turned off the fire alarms when they went off. They had there was a camera in the hallway that was pointed in the wrong direction, so no one could actually see anyone entering or leaving the cell if there was someone else involved. And the video recording for the collection of the forensic evidence afterwards cut out after only a few minutes, which means that there's not really a reliable way to evidence the chain of custody of the material in the cell, including the lighter that was found a few days into the investigation, which would have been hard to miss, many argue, in the first few days of the investigation. So all of this was basically had to be uncovered by the family and the lawyers for the family, who were only able to append themselves to the prosecutor's case. Because in Germany, you can't bring a private cause of action. Apparently, there is a very small window where you can bring a private cause of action for remedies. But this, in all the experience that I have and with all of the people who I've spoken to, including legal practitioners on this case, say that that would have been an impossibility. And that cause of action also wouldn't have necessarily rendered the type of prosecutorial rigor that would have been possible had the prosecutor brought charges of murder or even manslaughter in this case. But in this case, the prosecutor basically took the police's word for it that he burned himself to death, and he only went after charges of negligence. So in the past 15 years, the family, some of whom have passed away, the mom has passed away, but the brother is still alive, and activists have been working towards figuring out what happened to Oury Jalloh and trying to address the possibility that there was racism at play in either the arrest or the death or the treatment of the case by courts. And of course, that's a complex issue, particularly when you have to develop your own narrative about the patterns of treatment of Black people by the police in Germany. But that's part of what the activists have done. They've, over the years, amassed a kind of a catalog that is qualitative about how people are dying in policing situations, and in particular, how Black people, how people who have migrated to Germany, how people of color, how people who are down and out economically are treated by the police, and how their cases are handled. So, I mean, I think that's my introduction to how race and policing, and particularly Black Lives Matter, relate to the German context. And it kind of accompanies the piece that I wrote, Black Lives and German Exceptionalism, and kind of supplements, I think, some of what I mentioned in that article. So being that I'm a bit over time, I think I'll leave it there, and I look forward to our discussion.